Well, hello, everybody, and welcome to the Net Diligence Cyber Risk Summit. Really appreciate everybody taking time out today to attend our webinar. I realize that you may have attended a few other webinars today, as we have Net Diligence has a whole series of different webinars and some great topics. So again, thanks so much for taking the time today. So our session today, we're going to dive into a question. The question is before you, and that is the topic of our webinar. It is, what is remedy and what is improvement when you have a data breach scenario? Now, this is a question that I'm willing to bet that between myself and my panelists today, we've had to answer this question probably hundreds, if not thousands of times in our careers. Because essentially, what happens in a data breach scenario, you get through an investigation, you bring in your experts, your attorneys, your IT forensic firms, and ultimately, you're looking to take the bad guys out of your system. But then you come to a point where you have to ask that question, how are we going to remedy the situation? Are we going to sort of build the same wall up that we had built before with the same locks and the same controls? Or are we going to try to improve that control to make sure those bad guys can't get back in again? So the question then becomes, who's going to pay? Do I have coverage for that? How can this be done? So we're going to do a dive into that scenario with the experts that investigate these incidents, with the underwriters that write the coverage. And we're going to do it also with the background of the new regulation that has emerged in CCPA. So out of California, we have the California Consumer Privacy Act, where we're going to sort of look in some of the language there where this particular topic relates to the language in that particular regulation. Specifically, there is a cure language in there that basically allows you to cure whatever the issue was that led to the breach, and can hopefully, in doing that, help us fend off lawsuits and mitigate financial harm that may occur as lawsuits come in. So we're going to dive into some of that language as well. All right, so before we do that, though, we do have some housekeeping items to go over. So Heather Osborne, I'm going to turn it over to you to give the audience that information.
Hello, everyone. Welcome to Net Diligence Virtual Cyber Risk Summit. My name is Heather Osborne, and I'm the Director of Global Events and Programming at Net Diligence, a cyber risk assessment and data breach services company. Net Diligence is pleased to bring our thought-leading content to the virtual space with this new webinar series. Visit our website at www.netdiligence.com to get more information about our upcoming webinars and in-person events. Before we begin, I'd like to extend our heartfelt gratitude to our virtual Cyber Risk Summit sponsors, particularly Aspen Insurance, our diamond sponsor. I'd also like to thank our 100-plus speakers for bringing their thought leadership to our program. For today's webinar, we will be using the On24 platform. Right now, you should be viewing the On24 dashboard, which shows the live viewing screen. During the webcast, all participants will be in listen-only mode. Today's presentation is slated for approximately 45 minutes, with 15 minutes at the end for questions. Our panel of speakers will be taking questions throughout the session via the Questions widget. Please type in questions during the presentation and click Submit. If your question is of immediate import or concerns technical problems, you will receive an immediate answer by text. You can also find a widget entitled Resources, where you can download assets provided by the speakers and sponsors for each webinar. Just click the resource in the box and it will be automatically downloaded. If you are interested in receiving CLE or CE accreditation for this program, you must stay on for the full duration of the webinar and answer 3 polling questions that will appear during the course of the program. Additionally, please fill out the participant information questions. This will ensure that you are correctly matched to the state and professional organization. As a reminder, this webcast is being recorded. After the presentation, you will receive an archive link for further review or for sharing. The webinar will also be available for future viewing on our website. Again, thank you for joining the Net Diligence Virtual Cyber Risk Summit. We hope you enjoy the program.
Well, thank you, Heather, and thank you, everybody. Again, I wanted to sort of get back into this presentation and some of the content here, but before we do that, I wanted to give a little bit of time for introductions. First, I'll introduce myself. I am John Farley, and I'm the Managing Director of Arthur J. Gallagher's cyber practice. In that role, I sit in New York, but it's a national role where I basically help our clients ultimately become better at cyber risk management. We do that by helping them stay educated on all of the emerging issues surrounding cyber risk, ways to identify how the attacks are happening, how to prevent them, how to mitigate them, and very importantly, how to transfer those risks via cyber insurance. So we spend a lot of our time, guiding our clients through the cyber insurance market, which is ever-changing and can be complex at times. So that's really one of our main goals. So with that, I'm going to turn it over to Ron to introduce himself, and we'll go down the list of panelists, and we'll dive into the content. So Ron, let me turn it over to you.
Great. Thanks, John. And unfortunately, we're not all in Philadelphia together spending time over drinks and over dinner, but I'm certainly grateful for the opportunity to be a part of this webinar. I am Ron Raether. I'm a partner at Troutman Sanders. I lead the cybersecurity, information governance, and privacy group. I've been practicing in technology for over 25 years, dealing with a variety of privacy and alphabet soup issues. Started dealing with data incidents in 2005, being able to represent the very first two companies having to deal with, at that time, was a new law out of California requiring notice whenever there was a data breach. During that time frame, before and after, defended hundreds of class action lawsuits brought under a variety of those alphabet statutes. And more recently, have the pleasure of leading, and I live in California, and so from our California offices, the work that we've done for clients and on behalf of them, dealing with the California Consumer Privacy Act. And I want to thank everyone again for the opportunity to be part of this panel. Sean?
Yeah, thanks. Sean Curran. I lead the cybersecurity consulting firm at West Monroe Partners, primarily focused on the incident response and recovery side of our business. So while we're heavily involved in investigations and breach analysis in the event of a data or ransomware type attack, we're also really involved, more importantly, on the recovery side and helping businesses get back up and running, which when we talk about remedy and improvement, it becomes a very fine line between what we're putting in place to get the business up and running versus what may be considered improvement along the lines. Tim?
Thanks, Sean. Tim Francis. I'm the Enterprise Cyber Lead at Travelers, and in that capacity, I'm responsible for our cyber suite of products, what they cover, the underwriting strategy, as well as the pre-breach services that we provide with that and partner with our claims department and our forensics partners in managing through a variety of different issues. John, back to you.
All right. Thank you, Tim, and thank you to all the panelists for that background. All right, so before we dive into the full presentation, we're going to have a few polling questions that we'll ask you all to answer. So the first one we're going to ask right now involves your incident response plan. So, does your organization's incident response plan address how you would work with the IT forensics investigator to investigate, remediate, and improve your data security controls after a network intrusion? So if you could just answer this question as best you can, to the best of your knowledge. Again, does your organization's incident response plan address how you would work with the IT forensics investigator to investigate, remediate, and improve your data security controls after a network intrusion? So we'd ask you that you answer this as best you can, and what we'll do at the end of the presentation, we'll go over all of the responses, and we'll do an analysis of kind of what that looks like. Just give it a couple more seconds for everybody to answer that question. and we'll move right on into the presentation. All right, I'm going to dive into it. All right, so just on the agenda, we're going to have Tim go over some of the emerging cyber insurance coverages out there. And we'll talk about, ways that you might be able to transfer cyber risk as the market emerges. And then we're going to have Sean go over some of the best practices in IT forensics investigations, right? Where has he seen remedy work, and what are some of his ideas on improvement? And Ron's going to then dive into CCPA with some analysis of the cure language that I mentioned earlier, and how that might meet improvement, and how that might develop into a strategy for everybody here to help mitigate financial loss and sort of fend off some of those losses. And Ron will go into some of that strategy as well. So with that, I'm going to turn it over to Tim quick, just to sort of set the table as to what is typically covered under a standalone cyber insurance policy. So Tim, could you just kind of give the audience a bit of a background there?
Sure, John. And cyber policies really have evolved significantly over the last several years, and seemingly evolve every couple of months with new coverages, seemingly. But at its core, a cyber policy responds to data breach, and data breach typically involves personally identifiable information. There are circumstances that are broader than that, but at its core, that's what a cyber policy is for. But what tends to happen is there's a variety of different coverages that apply in any given scenario. So typically, if there's a system compromise and a data compromise, you're going to start off with some element of breach services. That may take the form of what we typically call a breach coach, working with outside counsel who are expert in cybersecurity events, and they're going to really act as almost the general contractor to the event. And so, for example, they may very well bring in forensics, and forensics is almost always brought in to really determine what is the scope of the event. Did bad guys actually get in the system? When did they get in? How did they get in? How long were they there? What data did they see? And certainly, are they still in the system, and try to get them out? So that can be a complicated, and it can be an expensive element depending on the breadth of the claim and the complexity of the software and how pervasive it's spread throughout the system and what data has been potentially seen. The notification varies by each state and jurisdiction, where you may have a person whose data has been compromised. And so if you have individuals in any data breach scenario that reside in different states, different countries, it's the particular jurisdiction that they reside in that is going to govern what you're required to do for those individuals. And so, again, that can be expensive and complicated, and one of the reasons that we have breach coaches who help manage our customers through that. The communications in this case really can be beyond the notification. Who else do you have to tell? How do you have to tell them? Who inside the organization is going to be charged to do that? So, for example, in a public relations scenario, if you've just notified a group of your customers, employees, or patients that their identified information has been compromised, you may very well have a PR nightmare on your hands, and we can work with you, and the policies can pay for those expenses. And then additionally, there's other legal expenses, particularly if we move into any regulatory environment or a liability lawsuit. Lastly, and particularly not only with data breach, but with ransomware incidents, there's often business interruption. So the system's been compromised in some way, degraded, potentially either taken offline or not working at its full capacity, and if the organization is unable to conduct their business and unable to make the money that they otherwise would have made, the insurance coverage can pay for that money that they would have made but can't but for this incident. And the last thing I'll say just real quickly is it's almost always most of these coverages kind of functioning together. It isn't like you have an incident and you just pay breach services or just pay forensics. Circumstances can vary, but usually multiple insuring agreements, multiple coverages are brought to bear on a single incident.
All right, Tim. Well, thanks for that summary. That's really helpful. One of the things I want to do, though, is focus on Curran, right? So Sean's going to take us through some of the next few slides, but I really want to sort of lean on him to learn a bit more about some of his real-world experience in helping our clients get back on their feet, remediating and perhaps improving systems. So Sean, I want to kind of turn it to you to kind of give us some of your insight into this. So take it away.
Yeah, thanks, John. And talk about the world of cybersecurity breaches. I think it's important to note that there's probably a much larger subset of breaches that we see today than maybe we were seeing 4 or 5 years ago. And on the one hand, the data breaches still exist and still manifest themselves, and that has an impact on consumers and the public alike, as well as potentially the employees of a company. But ransomware is obviously causing a much larger risk to organizations and their ability to function. And that's where we see a lot of the remedy necessary to help the business get back up and running and avoid that business interruption loss that was just mentioned. But today, what we're seeing is that combination of both. We see the ransomware attack coupled with the data breach that is resulting in sort of a two-pronged need for forensics. In a ransomware attack, you're really looking for what was the point of entry, and has that been shut down, and have we had the ability to address the risks there? When we talk about a data breach, it's more around what data has been exposed and potentially impacted to the organization, and therefore, going back to what was mentioned around the breach recovery and the communications and the like, all of that's necessary. So now when you think about the data breach process, the incident identification becomes important, understanding what happened and getting that clarification with the incident response partners, the law firms, the breach counsel, insurance carriers, and then the forensics firm. But what we see more and more today is on that remediation recovery and then potentially the betterment side of this. In most breaches today, you have to look at across the board. Someone is going to be trying to figure out attribution and determine what may or may not have been taken. But in a ransomware case or a business email compromise, the business wants to get back to operating as quickly as possible. It's going to take people thinking about the Active Directory environment and how you authenticate and authorize workstations in the environment. It's potentially data recovery of systems and the data that may have been encrypted in a ransomware. And then, in most cases, there's some kind of endpoint detection and response to make sure that the attackers have been locked out. Some of which is really riding a line of betterment or remedy versus really the incident response. Some of the things that of this is often the technical debt that an organization has. So if you're in an environment that maybe has been hit with a ransomware attack and you're trying to remediate that, or a data theft that has taken advantage of a known vulnerability in a particular platform, addressing that technical debt, could that be considered to be a breach response in recovery, or is that considered to be remedy? If we're looking at malware persistence and we're having to break down the way in which the malware is sitting within the environment or the way in which it's propagating to other systems, things like SMB1 attacks and the like, that may require us to disable functionality. In its essence, it's containing the malware, but at the same time is potentially also increasing the security posture of the organization. And the list goes on, whether it's infrastructure sprawl or whether it's the reliance on custom developed applications or the decentralized infrastructure management. All of these impact the ability for the organization to recover quickly. They're also the things that potentially need to be addressed to bring the business back up and running in a way that works and to lock the attackers out. So there's a very fine line between the two. And the forensics firm or the recovery firm are going to be rooted in trying to help you and the organizations to figure out both of these things. Where did the attacker get in? How are they maintaining persistence? And then what data may they have taken in the process? There's a lot of controls that go into minimizing the ability for the attackers to move within the network, and we talk about those in various forms. But a lot of these are the things that are considered partly remedy or potentially improvement, and it really comes down to the insurance carriers making a decision as to what may be considered to be one or the other. Things like separating the admin credentials from daily use doesn't have a huge amount of cost and probably isn't going to fall into that category. But the minute we start deploying endpoint detection and response tools like a Carbon Black or a CrowdStrike or something of that nature, there's going to be that question, is that betterment or is that really containment? And then decreasing the impact, addressing some of the gaps in logging that an organization may have, really increasing their ability to respond and recover quickly. Those are the things that potentially also run that same line but are necessary in a response.
All right. Well, thanks for that summary, Sean. That was fantastic, and especially highlighting how you can sort of not only sort of plug the hole but improve systems. And it brings us sort of back to a bit of a discussion to the insurance policy, and I want to sort of talk to Tim a little bit more about that because in the past, for those of us that have been in the industry long enough, I mean, what it used to be was we're simply going to pay for plugging the hole and getting you back to where you were before the breach happened. We're not going to pay for this vast new system that's going to cost lots of money. We're only going to bring you back to where you were. But obviously, as we've thought through that as an industry, I mean, ultimately what we want to do is get you or the clients in a position to prevent one of these incidents from happening again. So improving systems, right? Staying one step ahead of the hacker. So Tim, I want to kind of throw it back to you to get a little more commentary from you as to how cyber insurance has developed over time and what other coverages are out there, specifically what we know is betterment coverage. So could you kind of walk us through some of that to give us an idea of what's out there?
Sure, and I'll start off in the next, this slide and the next slide, talking about what betterment is and also what it isn't, and also just fair warning that this is a term that sometimes appears in policies and sometimes means different things depending on the particular policy and whose coverage it is. That's not necessarily unique in the cyberspace, but it's particularly important in this context to understand if you're looking at a policy and the term betterment is used, is how is it being used, because it can mean different things. So for purposes of this, right, we are talking about an insuring agreement that will essentially improve the system. And if we, talk about and we take what Sean said and I was talking about earlier in terms of the way the coverage works, traditionally somebody would have an event, we would pay, potentially a lot of money, and even if you're covering the cost of that event, nobody wants to go through that the first time. They certainly don't want to go through it a second time. And what was dawning on us, of course, was, well, we can bring in forensics and they can kind of clean up the problem, but they don't necessarily do anything to prevent it from happening again. And that traditionally hasn't been the role that we've asked them to do, and traditionally not what the cyber coverages were meant to do. But if you have an event, I think we could all agree it's in the insured's best interest and in the carrier's best interest to try to prevent that from happening again. And so betterment coverage in this context is to try to provide some coverage. Typically, it's going to be at a sublimit, and we'll talk a little bit about in the next slide, but some coverage to not only provide an incentive to the insured to fix the specific vulnerability that led to the problem, but give them some money to try to incentivize them to have that happen. And if they go in and are able to prevent another event from occurring, they're better off. The carrier is better off because they don't have a reoccurrence of the problem. So that's what betterment is in this context. The warning before is the term is sometimes used in conjunction with what we would call bricking, and that typically is referring to an incident in which somebody's physical device, their cell phone, their laptop, is rendered inoperable due to some event, whether it be ransomware or something else. And rather than simply paying the cost of the software, a carrier might say, well, it's in everybody's best interest just to pay for a new laptop. And in those contexts, you'll often still not have betterment. So in other words, if you were running a version of a laptop that is, we'll call it a standard model, we're not necessarily going to replace that with a model that's 10 times better. Typically, the language will say if we need to replace hardware in the bricking context, we'll give you something of equal value or similar to what you would, similar version, if it's a couple of years old, a version that's similar in purity to what it was then. Those are two, the term is used the same, but it means two different things in that context. So in the first context, we're not really fixing something that was broken. We're actually giving you something you never had to prevent the incident from occurring. And when we give that coverage, I talked a little bit about, typically that's going to be at a sublimit. Often there will be co-insurance that goes alongside of that. So if the carrier is going to pay $1, we would like the customer to pay $1 or some portion of it to really incentivize the behavior. We just don't want to necessarily give money that's not going to go directly towards the improvement. We want the insured to be invested in making that improvement actually work and making it something that becomes part of the functionality of the larger system. Pricing varies, depends on how much that limit is. It depends on the size of the organization. It depends on the vulnerability. Depends on the systems. The valuation of that is also going to be determined, and usually at the recommendation and the approval of an IT security professional that's making a recommendation that, yes, this particular software or hardware, had it been in place, would have prevented that incident from occurring, and that's the type of thing that we're likely to then pay for. And typically there's a time provision, right? It's not endless, but if you have an incident, typically it's 60, 90 days following the conclusion of that incident where we'd expect the insured to then pay for, and with our contribution, pay for the betterment coverage and the software or hardware solution to that problem.
Great, Tim. Thanks for that summary. That's really helpful. And, this is just really another example of how the industry really has learned how to pivot with threats as threats have evolved and improved coverage and really improved options for our clients in the industry. So, hats off to you, and those underwriters that offer this coverage, because at the end of the day, right, we're all aligned. We're all on the same page. We don't want the bad guys getting in again. So everybody has an interest here, and this is, in my opinion, one of the best developments in a while. So thanks for that. That's great. All right. So so this brings us to our next polling question, and that is, does your organization's insurance coverage pay for the cost to improve your data security controls after a cyber claim occurs? Again, does your organization's insurance coverage pay for costs to improve your data security controls after a cyber claim occurs? Just give you a couple more seconds. It's a yes, no, not sure, and we'll move on. All right. All right, so this brings us to the final section of our presentation, where we're going to do somewhat of a deep dive into some wording in the CCPA. So what we're going to try to do is connect some dots, right? We all want to improve our systems, and we hopefully have some insurance coverage to help us pay for that. And we're trying to connect it to a provision within CCPA, which is specific to a cure requirement that allows a breached organization to cure the issue or improve that issue or that control that led to the breach in the first place. So we want to do a little more of an analysis of this and see how it might be able to help us from a legal strategy. And so I'm going to turn it over to Ron to kind of dive into the next few slides. So Ron, I'm going to turn it over to you. Take it away.
Great. Thank you, John. So if the line between remedy and improvement was not gray enough, California has helped create more uncertainty with respect to the distinction. As everyone is probably familiar with, the California Consumer Protection Act was passed quickly and rapidly in order to avoid a referendum from coming into law. The referendum had numerous other requirements than what actually ended up in the statute. I'm not going to be able to talk about all of the statutory requirements, but I am going to focus on this cure provision and, more critically, the statutory damages that could be imposed on a company if they don't respond to a notice to cure or in other circumstances. So as I mentioned, the CCPA is not a statute that was written cautiously and carefully and over time. It was put together quickly, so as a consequence, the section that we're going to talk about, 1798.150, is the private right of action. When in the referendum and when the bill was originally presented to California, there was a private right of action included for violations of the privacy rights that are included in the CCPA. After amendment and what was actually enacted, that private right of action ended up being limited to just instances where there was a data breach under 1798.81.5. So we're going to talk about that. We're also going to put into context what a cure means. So in this case, referring back to the California breach notification statute, the practical application and limitations of responding to the notice to cure, how we're going to use thoughtful documentation in order to make sure we put ourselves in the best position possible to defend against claims from the regulators or putative class actions. But as many things in the CCPA, the term cure is not defined. So the CCPA does not define what cure means or to make things better. We could look at state, federal, and international regulations. We can look at class action activity. What's been argued in individual private right of actions, but ultimately we're going to start with the statute. So the CCPA did make its first debut in litigation, as we would anticipate and expect. The Plaintiffs' Counsel bar, they're each fighting over who's going to be the quote-unquote expert with respect to CCPA. They're doing that for tactical reasons. When multiple lawsuits are filed, we often see class counsel fighting under Rule 23G as to who's going to be lead counsel. The first case was filed in February 2020. It was a false alarm, and the primary reason was that the CCPA went into effect on January 1, 2020. The alleged incident that resulted in the breach notification happened prior to the effective date of the CCPA. I think it was a false alarm not only for that reason, but also plaintiff's argument that the CCPA itself includes a reasonable security procedure standard. It does not. In fact, that's not defined anywhere under California law, and we'll talk a little bit more about that later. But the two lessons from this case, one is the plaintiff's bar is extremely interested in using the CCPA, and I'll talk in a moment about why. So as I mentioned, the CCPA does not define cure and what it means. That statutory section in the CCPA is significant to us because it determines whether a consumer can make a claim for statutory damages or not. As all of us that's been involved in data breach incident class actions know, for the past really 16 years, we've been fighting, 14 years, we've been fighting over the issue of standing. Does the named plaintiff, does the class have standing? And the U.S. Supreme Court has done us somewhat of a favor by continually modifying what the law says on standing, not only with respect to that, but also with respect to damages. The CCPA seems to want to create an argument for plaintiff's counsel to avoid those standing and damages by providing for statutory damages. So we see the statutory damages in the class actions we defend in what I call the alphabet privacy statutes, so the Fair Credit Reporting Act, the TCPA, and the like. California, in enacting 1798.150, created statutory damages as a remedy for data breach under Section 1798.81.5. However, that right to statutory damages is not automatic. It only arises if the consumer who's affected makes notice of the violation, i.e. the implementation of unreasonable security procedures and practices, and the company fails to cure or respond to that notification. What's interesting for us is that what the statute requires, and this helps us go back to the remedy versus improvement point, that the violations have been cured and that no further violations shall occur. If the cure response is made in writing and then there's a similar event later on, then the company is subject to the statutory damages. So in the cure and notice requirement here, we have an interesting potential expansion of what's required to be done in the wake of an incident to deal not only with plugging the holes that may have caused the breach that's at issue, but doing something broader, creating improvements to the security practices of the victimized company to, quote, make sure that no further violation shall occur. What's interesting as well to me is that in the context of doing incident response plans and incident response tabletops, that's precisely one of the questions that we're continually asking ourselves. Is once we've gotten through the initial reaction to the event, bringing forensics in, plugging the holes, figuring out if there's been egress and the like, we're then turning to the lessons learned from the event and looking to better the processes to avoid something similar from happening again. Very interesting concepts in the context of the CCPA, what we've done in incident response plans generally, and how that relates to this remedy versus improvement point. So how do you deal with the cure? And it can be addressed in a number of different ways, but I think critically for us, and back to my comment on thoughtful documentation, we have to take care with respect to what we do. So cure can be a holistic response, right? We're dealing with the vulnerability, but we're also dealing with what I call the 3 legs of good cybersecurity. So technology, administrative controls, and physical controls. But importantly, what we need to do is make sure that we're documenting this process in 2 general ways. So one is understanding the case law and how it's developed with respect to forensic investigations. So courts are finding that business decisions are being made in response to those forensic investigations, and as a consequence, the attorney-client privilege doesn't apply. So the advice we've been giving to companies is to have a dual track segment, the forensic work that's being done to provide legal advice and the forensic work that's being done to respond and make business decisions with respect to the incident. We need a similar process with respect to notice and the cure. And in the notice letter, we need to be thoughtful about whether we're proactive. Do we include our cure in the notice letter so that we're not creating 2 documents or 3 documents, inconsistencies, issues that might cause the second part of the cure provision, no further violations shall occur, to become problematic for us. Alternatively, having multiple versions of the letters going to different consumers could help us with individual issues to defeat class certification. My point being is we want to be thoughtful. We want to think through, because each incident is going to be different. Not all of them are going to turn into litigation, and we need to be considerate about what we're going to do. If that wasn't complicated enough, the individuals that brought the original referendum have decided they're going to take another shot at this. We call it CCPA 2.0. There's some very interesting things that are developing with respect to that affect what we're talking about here. One is the definition of personal information. Is it going to be the narrow definition that's used in California's data breach statute, or is it going to be the more broader one that applies to the CCPA? That's obviously going to alter the advice we're giving to clients in the wake of an incident, but it's also going to change the scope of potential liability. and we all have examples of where we've been able to say, yeah, but the information that was accessed or egressed didn't fall within the definition of personal information, so I'm not providing a notice. This is going to be important to us as well as the possibility of California creating a privacy protection agency. So something similar to what was done under Dodd-Frank with the CFPB. This is going to be an independent board. What's interesting to me is whether that board is going to actually provide some more guidance on what reasonable security procedures and practices actually mean. As I've talked about before, there's no real standards on such issues, so we're looking to the CES Top 20, we're looking to NIST, the FFEIC self-assessment controls, none of which are really standards, but nonetheless, that's the best that we can do. And the notice and cure, there's a clarification that's kind of interesting from my perspective. One of the things you haven't heard me talk about so far is whether the cure provision requires any remedial benefits to the affected consumers themselves. For example, credit monitoring. That does it include prompt notice, because we've seen those notice, failure to timely provide notice as claims in putative class actions that we've seen to date. Again, it'll be interesting to see if the referendum gets passed, if it causes the California legislators to make adjustments. In the end, our approach is going to vary. We need to be thinking holistically, but we need to be looking around the corner as to what and how the information might be used in litigation. Real quickly, so as I've mentioned, I'm not going to be able to deal with all of the CCPA issues that will be confronting and have been confronting, but this slide does make an important point with respect to litigation. And if you want to read more about it, there are materials available in the resource section that will help fill in some of these gaps, and I'm obviously available to answer any questions. But the real takeaway is that with compliance with the CCPA would have provided defenses to the litigation that Facebook faced in the internet tracking litigation. So I think there's lessons to be learned there, not just for compliance with the privacy provisions of the CCPA, but also as the law begins to evolve and develop, dealing with the notice and cure and the more cybersecurity issues that are addressed by the CCPA and California law. Thanks, John.
Have some final discussion points. And really, I posed a question, and I'm posing it to each one of our panelists right now, and I'd hope each one can kind of give their take on what should be the primary focus of businesses going forward in light of all that's going on, in light of all that we've discussed here. And I'm interested to hear from Tim, from the insurance perspective, and the other panelists from their areas of expertise. So maybe we'll kick it off to Tim to sort of give his take, and then we'll just go down the line and to Sean and Ron. So Tim, what's your thought on this final discussion point?
Well, I'm going to maybe take it in a different direction, just back to basics, right? We've talked about all of the things that kind of go into the event, dealing with it and the coverage. And I would just like to stress that, even if betterment coverage is in your policy and you've done the things towards the cure, first and foremost, I would hope that organizations, if they haven't already, are getting a sense of the complexity of the issues that are facing, the sophistication of some of the software that's out there being used against them, and really the complicated factor of dealing with these events, and then of course the expense. And so all of that in my mind is leaning towards, an ounce of prevention is worth a pound of cure, and making sure that the organizations have as good a best practice as they can. And, in some of the earlier slides, we talked about things like segmentation, EDR. Those things done before an event is absolutely important, and to help to reduce the chances that you're going to have it, or reduce the chances of it, reduce the cost of it should it still occur.
Great. All right. So, Sean, what about you in terms of, IT forensics and then getting to the point of improving systems? and remediating them. What are your thoughts? Where should be the focus in that end?
I tend to agree. I think it's hard not to say prevention is going to be the better part of cure, right? But I think the reality for most organisations is recognising where to invest those dollars to get the best bang for their buck. They're not going to be able to spend huge amounts of dollars to minimise or mitigate all of the various risks that exist out there. So understanding their risk profile, what type of attack are they really at risk from? A manufacturing firm is going to be very different from a financial institution, which is going to be very different from a retail organisation from a risk standpoint. So understand that risk profile and then build your security controls in an attempt to try and withstand the types of attacks that may be levied against you. Once you do that, there is a lot of opportunities today to reasonably implement security controls. MFA 10 years ago used to cost you an arm and a leg. It was probably $1 million base level just to get into. Nowadays, it's part of Microsoft licensing costs on O365. So, the barrier to entry into cybersecurity isn't what it used to be, and it's not that difficult. Segmentation and separation at the network level used to be, the investment in large, high-quality switches from Cisco and other vendors. Nowadays, most of the non-enterprise, even consumer-grade switches support some kind of segmentation and separation. So that barrier to entry needs to be where people recognise that their investment can be going to and start to make some of those changes today. They're simple. And also realising that out of the box, most of these technologies are insecure. So, implement those security controls now before they become a problem.
Great summary. And then finally, I want to turn it over to Ron. From a legal strategy, where do we focus, Ron?
Sure. I would start with what I call thoughtful documentation. So I've spoken about before the need to be prepared for third-party scrutiny. So whether it's a regulator, whether it's plaintiff's counsel, whether it's an audit committee, or a third-party auditor. And by thoughtful documentation, I mean explaining why your security controls are reasonable. So there really are no standards out there that can be looked at and to say, if I check the box here, my controls are reasonable. We can look at NIST, we can look at the CIS 20 controls. I'm a big fan of the self-assessment tools like the one that FFEIC put out, but document beforehand why your controls are reasonable. When an incident occurs, be thoughtful there as well. So if we look at the notice and cure language in the CCPA, it says that we have, in order to avoid the statutory damages in our response, where we're saying we're curing, we have to state that the violations have been cured and that no further violations shall occur. Pretty high bar, but by that, I think it's important for companies to exercise the right effort in response to the incident. So I've been involved in situations where the company doesn't want to invest in a forensic firm. They think that they can self-help in terms that their technology group is sophisticated enough. They then want to focus on what I would call plugging the holes, so just remedying and not doing a deeper dive to figure out where other vulnerabilities may be, looking at system improvements. I think the CCPA creates a tremendous amount of danger if that approach is continued to be taken by companies. Likewise, in documenting, I talked earlier about having some segmentations and parallel paths in terms of doing investigations, and because of the privilege issues we're seeing in the courts, that may mean hiring 2 different forensic firms. But at the end of the day, to me, it comes back to thoughtful documentation, all the way through that to our breach notification letter, to the documents that we're using that we know eventually will become part of the evidence in any case.
All right. Well, great points from all our panelists. Really do appreciate that insight. I do want to turn it over to our polling question here for the audience. So the final question is, how familiar are you with the cure provision in the CCPA regulation? Obviously, you're going to know a lot more now, but I mean, just on the surface here, were you familiar with it going in here? Were you very familiar somewhat or not familiar at all? Understandably, I mean, this is a complex subject. I wouldn't be surprised if many were not familiar. But what we're trying to do here is really sort of highlight what exists out there in terms of cure, what the requirements are, and how we might be able to meet it. So, again, if you could just tell us how familiar you are with the cure provision in the CCPA regulation. And we'll just give it a few more seconds for people to answer. All right, so I am now going to turn it over to questions. Again, type in the chat box the questions you have. I know we're going to have many to get through, and we may not get to all of them, but we're going to do our best to answer as many as we possibly can. Okay, well, we've covered a lot of ground here, and I know our panelists have been answering questions from the audience as they came in during the presentation. So hopefully all of you have seen that Q&A. But we do have about 9 or 10 more minutes left for some live Q&A, and there are still a number of other questions that we haven't been able to get to yet. So thank you, audience members, for all of those great questions. So we'll take this time to answer a few of those. So I'm going to turn it over to Tim. I know there's a couple of insurance-related questions. So Tim, do you want to take one of those and try to answer them?
Yeah. I think there was a follow-up question on the betterment coverage, and if I'm understanding the question correctly, it had to do with end-of-life systems, and also importantly, is it mandatory? Can an insured kind of elect or not elect the betterment coverage? And certainly, it's up to the insured to choose to exercise the betterment coverage if they want. And really, the intent of that, and one of the reasons there's relatively low sublimit and a co-insurance provision is not to provide a bucket of money to replace an entire system from scratch, but to look at the specific vulnerability that may have led to a claim and put in a specific solution to prevent that vulnerability from occurring. But because there's a co-insurance provision, typically at 50%, so essentially every dollar the insured puts in, the carrier will match, it's up to the insured whether they want to take advantage of that or not.
All right. Well, thank you for that, Tim. Thanks for clarifying the coverage there. We've got a couple more questions. I want to move to Sean related to some IT-specific questions. So Sean, why don't you just take one from that set of questions and try to answer. So I'll turn it over to you, Sean.
Yeah, thanks. So I think sort of along that same lines of end-of-life systems, I think there was a question around the complexities associated with those. So a little bit in the same vein, but I think what drives part of the question or the challenge for many organisations is there's typically a reason why they're running end-of-life systems. It isn't always just because they haven't got around to upgrading. Quite often they've got software packages or technology in place that they need to continue to operate their business. It could be either they have replaced the technology, but they need it for regulatory requirements to continue to operate those aging platforms to be able to get data back out. We see that a lot in financial services, or it could be just that the complexity of migrating to the newer platforms is just beyond the financial benefit to the organisation or that they believe, and so there hasn't been a business case to do so. And when you talk about recovery, the time taken to migrate from one aging platform to a newer platform may be well beyond the time you want to be able to recover. The flip side of that is, in an environment that has both new and aging technology, for instance, Windows 7 running in the environment, it may be cheaper to actually deploy newer technology than it is to go and deploy a mixed bag of Windows 10 and Windows 7 in the environment. And that's just from the total cost of deployment would go up if you're trying to deploy different technology to different users and the like. So it becomes pretty complex, and it's a question that really comes down to the business and the business impact of that technology.
Yeah, no, great points. I mean, sometimes trying to replace, or try to get the same system you had in place it's an obsolete system, and it's really almost an impossibility. And even if it is possible, again, it can be more expensive to do that than get the latest system. So it's always it's a great point and a great question. So thank you to the audience for that. I want to turn it over to Ron. I know we've got a few questions on some of the legal side of this related to, maybe some other states following California, right? We know that California leads the way, but we tend to find other states follow California historically in privacy regs. So let me turn it over to Ron to answer a question or two there.
Sure, thanks, John. So we've seen bills introduced in a number of other states, not unlike after California enacted the breach notification statute. Other states followed suit, have wanted to make modifications/improvements, or at least what they perceive to be improvements to the California bill or the California statute. None of those bills have really progressed or gone forward, mainly because of some of the more controversial points in the CCPA, such as a private right of action to pursue privacy claims. It's going to be interesting to see how CCPA 2.0 alters the landscape, the legislative landscape in other states, assuming that it gets passed or that there is a reaction by the California legislature to CCPA 2.0. I think ultimately what we can look forward to is likely a federal legislation. So while we've not seen it on the data breach side, I think privacy comes with a lot more complexities, nuances, and frankly has a larger impact on interstate commerce. So I wouldn't be surprised if we don't see something at the federal level. Obviously, that's going to depend on the outcome of the elections this fall.
Yeah, and if you think about it, I mean, back when the AGs got together a few years ago, when they were basically demanding that they get to retain the right to sort of make their data breach notification stronger if they want to. I mean, maybe there'll be some of that, but we don't really know. And I think I agree with your point there, Ron. I mean, this is a much more complex endeavor, right? I mean, to just comply with what CCPA requires, right? And then can you imagine having 49 other states with their own complex set of compliance requirements? It could be just a nightmare scenario for the average business. We'll have to see what happens there and whether or not the AGs want to take a stronger stance or federalize this thing. So really one to watch there. Any other questions that the panel wants to answer? We've got about 2 or 3 more minutes, so probably have enough time for one more question. Anybody on the panel have anything they want to address?
I could pick up on what Sean was saying earlier, and I think it's demonstrating complexities around the question of security standards. So what constitutes a reasonable security standard? And unfortunately, just like when we're talking about reasonableness in any other context, the question is not going to be easily answered. I think that what we can do is look to guidance that's out there. So making sure we're at least checking the boxes on the CIS top 20, used to be the SANS 20. Looking at NIST, what I recommend and what I think is beneficial, not just from a legal perspective, but frankly from a general improvement of cybersecurity and moving that ball forward, is adopting something like the FFEIC self-assessment tool. So in other words, creating measures, understanding that cybersecurity is not an event, it's an iterative process, and putting in place the documentation, again, purposeful documentation, that's going to establish that the company continues to assess cybersecurity and, importantly, is moving the ball forward in those critical 20 areas.
That's great. Well, we're down to our last minute, so I really want to take this last minute to first of all thank our panelists who did just a tremendous job in helping us all sort of understand a fairly complex topic and sort of tie it all together based on all of our collective expertise, whether that's insurance, whether that's IT, whether that's the legal field, right? I mean, all three of those areas are evolving as we speak. So when we come to a situation like CCPA and CURE, and we can kind of pull all of these disciplines together, I think it's just a fantastic thing to see. I mean, really, getting these bright minds together to help come up with solutions to this kind of thing is really what this is all about, and really what this conference is all about. So, again, I want to thank the panelists for really taking the time out to sort of sort through all of this. And I'd also like to thank the audience members for really putting forth some really thought-provoking questions for us. So, again, this is a moving target. It's going to continue to evolve. But I think as we come together on a regular basis to address these issues, tackle these issues, we're all going to be better off for it. Our organizations that we serve will be better off for it. So again, thank you all. We're at the end of our hour. Appreciate the questions, and reach out to any of us. You have our contact information. We're happy to answer more questions that we didn't have time for today. So thank you very much.